to fulfill all your expectations, and I will maintain your sense of nerve and verve with regard to your excitement, your intellectual agitation, as well as your cooperation, and whatever the inputs you think are appropriate would also be reflected in my submissions.
Sir, is there any possibility of yours coming at sound?
Pardon?
So are you coming at SAU in next week or some nearly days?
Yeah, I will. Definitely, I will come. So what do you want? Tell me.
No, sir, just to see after a long time. We are excited
Yeah,
to
that I
meet all of
understand.
you.
I am equally avid. I am equally avid to see your facial contortions, physical interaction, one-to-one talk. But if you need anything, you can also email me, and I will also, on individual basis, I will share a link individually. If any individual is having some kind of an interaction, one-to-one interaction, so I would also be having those interactions by sending as per the contact hours. That has also become the part of the timetable. So I am thinking that I should also share uh, individual links to invite on the basis of your email, on the basis of your telephonic conversations, so I can arrange one-to-one talk online. So whenever you feel necessary, I will definitely send you a link.
Yeah, sure, sir. Thank you, sir.
Yeah, please don't worry on that count. I am, all my 24 hours are at your disposal, so I will never let you down. Yeah. Yeah, welcome, Miss Prakriti Malla and Mr. Jamshed. Thank you for joining.
Thank you, sir. Good morning,
Good
sir.
morning, ma'am. Good morning.
How are you,
morning,
sir?
I'm fine.
How is your health?
Yeah, I am feeling top of the world whenever, some kind of semblance of goodness is there. So as it is axiomatic from my expressions, my language, how I have been, I mean, submitting my thoughts, as well as a little bit courtesies, whatever I am exchanging right now. So it is very much evident from them that I am feeling well. So how are you?
I'm fine, sir. Thank you, sir.
So do you have any information, Miss Anupa, how many of you have joined as of now?
Sorry, sir, I don't know how many of us are going to be joined.
Okay. So I have a submission to all of you. There are students, I don't know, this year only one student has approached from Department of Sociology. So there are students from International Relations, from Department of Sociology. They have always been the part of this optional program on international refugee law. So I think around 10 students, 8 students from both the departments have always been there on the rolls of international refugee law. Whenever you come across or somebody ask you, just share the link with them of the online class. You are most welcome. Anyway, let us begin in a formal sense. After making my presentations regarding an international canvas of refugee mobility, migrations, position of displaced people across the world, that was the one important submission. Another important, the second most important submission regarding the overview of entire course structure. And today we are going to begin a prima facie understanding of international refugee law and refugees per se. And we have to take into account this entire prima facie understanding of international refugee law, and thereafter we would be switching over to different historical roots of the population movements as well. International refugee law, my dear friends, and particularly the scholarship of IRL, has long been dominated by a positivist tradition within which the human rights-based approach has now become the dominant approach in understanding various niceties, nuances, and other important dynamics, dimensions of international refugee law and refugee mobility. However, states now become the, when we are talking of the responses of the legal institutional responses from the states, then the states and their formal agreements get us only so far in explaining how refugees is created and how international law develops. There is another important layer of such an explanation when we are talking of approaches to international refugee law that looks into transnational activities and their effect on how law is shaped, interpreted, applied, and developed. Therefore, if you take into account, since the inception of international refugee law in the form of 1951 UN Convention relating to the status of refugees, and we are here in the year 2021. It means in the months ahead, this international document in the form of 1951 UN Convention relating to the status of refugees is going to complete its 70 years of its existence. So we have to take stock of the situation and what has been the overall cumulative impact of this kind of an arrangement, along with the 1967 additional protocol that made this regional convention as international or universal one. Therefore, there are two further emerging approaches to international refugee law, and that is number one approach. Though there are many intersectionalities of these two approaches, there are certain important intra-fragmentations of this kind of approach. One approach is known as transnational approach, and the second one is participatory approach. But there are scholars in the area of international refugee law, my dear friends, who are of the view that these two approaches are not sufficient to address the miasma of this kind of a problem, which has attained regional, continental, transnational, international, universal ramifications. So we cannot confine, and it is not at all possible to deal with the problem of refugees with a single approach. This scholarship argues that whereas the dominant human rights-based approach or human rights approach, or we may call it the HRBA, and HRBA focuses mainly on sources and contents of rules when we are talking of, and their definitely implementation and enforcement. Both the transnational and participatory approaches are useful in capturing the complexities of the process of law formation and law development by looking more specifically at networks and other participants in the process of law making with regard to international refugee law. The challenge of contemporary international refugee law is to recognize more explicitly the role of such networks of approaches, and to what extent the soft law as well as the norms that they often produced. The approaches have been producing this kind of norms as well as the soft law. To what extent these networks of approaches have been successful in addressing the problems of refugees, that remains to be deliberated, cajoled, and rummaged. Because the movement of 79.5 million refugees by the end of 2019 across the world brought long needed attention to the inadequacy of the global humanitarian system. Though there have been scholars like Erika Feller, like David Kennedy, like Professor B.S. Shimley, like late Professor R.P. Anand, and some other important, Asian scholarship or Afro-Asian scholarship, particularly Professor Anji, Professor Matwa from Africa. There is no dearth of this kind of a scholarship who has expressed their concerns. And they have expressed categorically that the international humanitarian system remains inadequate in addressing the problems of refugees. The international regime governing the reception and treatment of refugees was put in place at the end of the so-called World War II, which I do not concur with. Because I am having problem with this kind of an expression called Second World War and First World War. These were the, global North Wars. The First World War should rightly be attributed as global North War first. And the Second World War should be addressed as the Europe Wars, second. Or the Europe War, exclusively first. That remains to be, deliberated on some other occasions. Definitely, I would also be coming. Why I am, not concurring, why I feel that it is problematic, I would definitely be, offering my submissions on this particular point. Right now, I am also deliberating in a research paper on these particular, aspects. And very significant, I mean, more than a dozen pages I have devoted to this particular, line of argument from my side. I would definitely share during these online classes with all of you, just to agitate, just to what we call, intellectually entice you to have second thoughts on this particular, line of argument. But since there is an emplacement of international refugee law system that was contemplated under the statute of United Nations High Commissioner for Refugees in the year 1950. And in the subsequent year, 1951, convention, UN convention relating to the status of refugees was also promulgated. But here lies one of the most important questions. Does UN Convention on Refugee remain fit for this purpose? Because the peoples, I mean the scholarships across the jurisdictions, particularly the Afro-Asian scholarships, have been demanding and challenging for an appropriate what we call, solution and response. Because it has been further what we call their question, which they have been what we call raising as a challenge, is further, legitimized because of certain important, developments. I am taking two important developments for your deliberations, which have been affecting Europe as well as South Asia. The chaotic and tragic images of the Syrians fleeing across the Aegeans are reported on a daily basis. But nowadays, we are not getting any kind of a proper highlighting. And these, migrations along the, Mediterranean Sea have not been what we call, getting or not hogging the limelights of the international media. Another important, development is Rohingya refugees from Myanmar. And these, Rohingya refugees also flee across the Indian Ocean. In both these cases, and many more, states achieve orderly receptions and resettlement plans for the refugees, and show little solidarity with the first asylum countries. So in such a situation, if I put a question for your consideration, how can states be convinced to cooperate to provide the protection of all agree is necessary? rather than compete to impose ever harsher barriers and restrictions for the purposes of entry of these refugees in both the cases. I am not underestimating here the Mexican refugees, Venezuelan refugees, or other important what we call refugee groups, including the Palestinian ones. And the number of refugees, asylum seekers, migrants, and stateless, I call them in abbreviation RAMS, RAMS, and other displaced people, reached the levels which have never been witnessed since the so-called World War II. And there is a need for new approaches, and this need has become indispensable, inevitable in understanding what exactly should be the preferred approach dealing with a humanitarian crisis. The worldwide sense of crisis gave rise to an extraordinary series in recent past, international conferences and meetings to specifically address the movement of RAMs across the international jurisdictions. These international events have produced some practical, concrete outcomes, my dear friends, such as new funding for humanitarian relief, locating new resettlement places for the refugees or RAMs, and evolving new approaches to development projects that include the RAMs. They also promoted broader rethinking of the relationship between development, mobility, and protection. And one such examples could be given here at this stage, what exactly has been the concrete outcomes. Then I see the conclusion and adoption of one of the most important declaration in the recent past, that is 2016 New York UN Declaration, and that has been the outcome of a UN summit, my dear friends, whereunder it has set out a broad set of commitments on responsibility sharing, protection of refugees, and the orderly and safe migration, which was ultimately concretized in the year 2008 in the month of December, when for the first time the 2016 New York Declaration was translated into action. And it has been received by the community of nation states in the form of two important compacts, that is the Global Compact on Refugees and the Global Compact on Migration. But the commitments which have been agreed upon under these two important compacts, and how to translate them into reality, presents a major challenge for the international cooperation, international responsibility sharing principles, international solidarity norms, and other important dimensions of international law. That is the current scenario of international refugee law. But at the same time, we are supposed to understand, my dear friends, what has been the history of refugee movement. It is axiomatic from the working of the United Nations High Commissioner for Refugees and its humanitarian partners, how they have undertaken increasing pressure to meet protection needs in the world's conflict zones, despite growing threats to the security of the aid workers and the constants in accessing populations in the dire what we call hostile situations. And they require immediate relief. The biggest casualty in any kind of a refugee crisis ever since the inception of humanity on this beautiful planet, that has been the individual liberty. Individual liberty is portrayed as one of the great moral achievements of capitalism, in contrast with the earlier societies where liberty was restricted by traditional bondage and servitude. The post-1945 migrations may be new in scale and scope, but population movements in reaction to demographic growth, climate change, and the development of production and trade have always been part of human history. And cumulatively, these circumstances as well as situations have pandered to human migration. Sometimes it has been the forced migration or the forced displacement of people. Sometimes this kind of a displacement has been conflict-induced, violence-induced. Because the warfare, conquest, formation of nation-states and the emergence of the states and empires have all led to migrations, both voluntary and forced one or involuntary migrations. This is how we should try to understand the entire canvas of the world history or the history of the population movements. Because the enslavement and deportation of the conquered people was a frequent early form of labor migration, and it has been, whether it is the plantation workers, whether it was what we call migrations of the blacks and their enslavement by the white people, and they have been transported to United States of America, or Irish people were also enslaved and they have also been forced to migrate and taken into enslavement and transported to the new lands of the British Empire, that is United States of America. So you can very well understand that from the end of the Middle Ages, the development of European states and their colonization, my dear friends, of the rest of the world gave a new impetus to international migrations of many different kinds. In Western Europe, migration was a long-standing and important facet of social life and the political economy. From about 1650 onwards, if I'm not wrong, and that has also been playing a vital role in the modernizations and industrialization of entire European region. The denial of the role of immigrants in the nation building has been crucial to the creation of myths and the national homogeneity. The devastating effects of the international migration on the indigenous peoples of the colonized countries. Suppose it is also axiomatic from certain important examples like the conquest of Europe, particularly of Africa, Asia, America, Oceania, that ultimately led either to the dominion or exploitation of native peoples or to genocide, both physical as well as cultural. Nation building, particularly in the Americas and Oceania, was based on the importation of new populations, arrival of the new populations. They have been employed. On the other hand, my dear friends, the European colonialism pandered to various types of migration. The large outward movement from Europe first to Africa and Asia, then to the Americas, and later to Oceania. Europeans migrated either permanently or temporarily as sailors, soldiers, farmers, traders, fleets, administrators. Around half of the soldiers and sailors of the Dutch East India Company in the 17th and 18th centuries were not Dutch, but trans migrants mainly from poor areas of Germany. In the later half of the 19th century, slaves were replaced by indentured workers as the main source of plantation labor. In Indenture was a kind of a coolie system, my dear friends. And it involved recruitment of large groups of workers, sometimes by force, and their transportation to another area for work. British colonial authorities recruited workers from the Indian subcontinent as well for the sugar plantations of Trinidad, British Guiana, and other Caribbean countries. And indentured workers were used in 40 countries by all the major colonial powers or other important empires. Indentured workers were bound by strict labor contracts for a period of several years. Indentured workers were often cheaper for their employers than the slaves. It was some kind of a bonded labor. On the other hand, work overseas offered an opportunity to escape poverty and repressive situations such as the Indian caste system. For example, we can count this kind of social evil. Many workers remained as free settlers in East Africa, the Caribbean countries, like Fiji and elsewhere, where they could obtain land or set up businesses. So that was also some kind of enticement for them to be a part of this kind of group or the population called indentured workers. Primarily, indenture epitomized the principle of divide and rule. Though in the current situation, the policy of the divide and rule has already been replaced with another important expression, divided to rule. And when we are talking of divide and rule, then a number of post-colonial conflicts, for example, hostility against Indians in Africa and Fiji, because it is also axiomatic what kind of a treatment was given to our father of nation, Indian father of nation, Mr. M.K. Gandhi in South Africa. And there was also hostility against Chinese in Southeast Asia, and that is still re-emerging because of the policy of death trap that is being actively pursued by the Chinese government in the name of what we call of producing and laying down infrastructural facilities in the name of the new Silk routes in different directions from China, and these directions encapsulates all the continents. So these have been the divisions of indentured working conditions. So primarily, if you divide, or if we divide this entire canvas with regard to the history of the population movements, then the industrialization and migration to North America and Oceania before 1914. That is one important phase. Then the functioning of the labor migration and performance of the labor migration within the Europe. That is another important what we call categorization. Then the people's movement, particularly during interwar period, forced people movement and how the peoples were compelled to migrate from one place to another place, and what kind of a migration, relocation and resettlement has taken place during interwar period. That is another important categorizations. Then there is another important stage, that is the migration in the age of global economic rearrangement. How the entire global economic arrangement has been rejigged So this rejiggings, how it has influenced, that is another important addition of a new category of what we call of forced migration, then the contemporary trends of migration in various parts of the world. This is how we should try to understand. Because the history of the protection of refugees, my dear friends, dates back at least a few centuries. Not to mention a refugee situations in antiquity, the history of international protection starts with the League of Nations. The evolution of the modern law on refugee situations and refugee protection, tracing its roots to early experiences in providing safety and security to wayfaring strangers via institutions such as Ijara or Aman among Muslim communities and sanctuary in the Judeo-Christian traditions. Sanctuary cities weeks are also celebrated right now even in Great Britain. And in 2016, I have also been the part of the sanctuary for refugees cities in England. So they also, some specific urban centers have been designated as sanctuary cities for refugees in many European nation states. As a part of what we call of traditions and how to treat refugees, what kind of integration should be contemplated for them, whether it is integration, assimilation, or resettlement. But these sanctuaries in Europe, sanctuary cities for your refugee receptions have been provided. But before turning the League of Nations, which established the first High Commissioner for Russian refugees, my dear friends, and eventually the United Nations and its 1951 UN Convention relating to the status of refugees, along with its additional protocol of 1967. No one would be surprised to learn that the International Committee of Red Cross was the initiator, my dear friends, of international protection system set up by the League of Nations. You might have studied in your international humanitarian law classes something about a war that is popularly known as the Battle of Solferino, and how Henry Dwan got influenced, and this particular war of Europe, Battle of Solferino, that has left an indelible impression upon the minds of Henry Dwan, who ultimately established the International Committee of Red Cross. And thereafter, Treaty of Westphalia, though it is prior to that, because it is of Battle of Solferino, I think, is of 1862, and the Treaty of Westphalia hails almost what we call 2 centuries before, and that is the 1648. So the Treaty of Westphalia in 1648 primarily evolved the refugee regime and given us an impression of the refugee regime with our modern what we call state system, where we find a reflection of changes in the international law, politics, economics, notions of ideology, and other important what we call the political transformations of the global north and global south, and some kind of balance of power at international level. Since the early religious and political persecutions of the Huguenots, then the aristocrats of the French Revolution, who were popularly known as Huguenots, more comprehensive refugee regime finally emerged, my dear friends, under the auspices of the League of Nations immediately after the First World War. This regime under the League of Nations responded to circumstances undergoing dramatic what we call changes during the Second World War to create a permanent framework to cope with the refugee problem through the United Nations High Commission for Refugees. Then the Cold War. Cold War had an overwhelming influence on the norms and policies upon this particular regime. And in the post-Cold War era, the regime has had to reflect global concerns. States or the nation states began to respond to refugees in a cooperative manner soon after the Peace of Westphalia in 1648. Because this particular treaty has played an important role in rendering notions of refugee and asylum into an understandable form within the then emergent European state system. The Peace Treaty of Westphalia of 1648 did this by affirming a basic right for emigration by these wishing to leave their own state because their religion differed from that of their prince, kings, and rulers. That was the bone of contention. Because there had been a political tradition during this particular period, or in the circumstances in which the Treaty of Westphalia was adopted in 1648. The subjects were expected under the monarchies and some oligarchies and some other important crises. The religion of the king or the prince or the ruler has always been the religion of the subjects. It has always been some kind of an unwritten law. And in many situations, it has also been witnessed, my dear friends, that a considerable size of people, a chunk of population was also compelled to embrace the religion of the king. This has also ensued a migration of people because of the religious differences, because the religion of the subjects differed from that of the king. That is why they also preferred migration, relocation, and resettlement in the third countries or some other, locations. How they have, exercised this right to religion. Then this right was listed in the piece as a right of jus emigrandi, or right of emigrants, or right to emigrate. It also included their personal property. It means right to emigrate with someone's personal belongings and someone's personal property. Then we can divide this entire evolutionary phase of international cooperation for the preservation, protection, of refugees, asylum seekers, migrants, and stateless persons during those days into different phases. So I have identified as many as 5 important phases. And I perceive these important phases with the developments of different what we call dimensions and the dynamics of protection of refugees. Because I have considered the Treaty of Westphalia of 1648. That year was considered as a base year. And 1648 onwards, certain important phases, I mean the entire period of history with regard to the treatment of refugees, protection of refugees, with the current what we call scenario into 5 important phases. Phase first starts, and we find in this very first phase, which I call as the initial stage of transition, or you may also call it the very first phase, or the first what you call stage of transition, that starts from 1648 and goes up to what you call 1685. Then the second phase that starts from 1685 and goes up to 1914. This is the phase when I was studying this particular phase of developments with regard to the treatment of refugees. I come across a pervading line of argument that was exclusively dedicated, which can be called as an expression called laissez-faire. So this is the second stage of migration. Then there is a third stage. This is of vital importance, my dear friends. It starts from the 1918 and goes up to 1939. It takes into account very important phase of the interwar period, as well as what we call the initial stages of the Second World War, so-called Second World War. And we witness in this particular important phase of the refugee movement, or the history of the population transfers as well as the population movements, at continental level, at international level, at global level, or as well as what we call a regional level. Because an attempt has been made by the stakeholders in this particular, and as well as the scholarship of this particular, period, an attempt has been made, and that attempt was in the direction to identify what kind of a movement has been there during this particular, period of history. And we come across a very, very important expression that is known as an attempted industrialization. In this particular period of human movement, or the human mobility, or the refugee mobility, or the migrants, what we call, we find attempted internationalization. Though it was backed by some kind of a industrialization as well. But within inverted commas, we should remember that the third stage, or the third phase of transition, is known as attempted internationalization or globalization of human population movement. Then there is another important stage, that is the fourth stage, that starts from 1939 and goes up to 1951, the year in which the current what we call subject matter, or the instrument of law that addresses the problem of refugees, that is 1951 UN Convention relating to the status of refugees, has been adopted. So this is the fourth what we call age, or the fourth stage. It should be addressed as the second transition. First, it was the first transition, the period of laissez-faire, then the attempted internationalization. Now it is the second true what we call transition, where for the first time we have witnessed intra-European migration in the wake of Europe War II, or so-called Second World War, where we for the first time has witnessed, because under the auspices of the United Nations organization, my dear friends, this particular period of the human history of war, we have witnessed not international migration. There was no global migration fleeing from persecution or fleeing from war and conflict. Rather, we have witnessed for the first time a continental, and it was basically intra-continental migration, which was limited and exclusively confined within the borders of Europe, in the wake of, in the aftermath of Second World War, so-called Second World War. So therefore, it is known as the second phase. Then there is another important phase, and that is the what we call the fifth phase, which I perceive as effective internationalization. First, an attempt was there an attempt has been made to internationally understand that there is a refugee migration. And now it is the most efficacious, effective, pragmatic internationalization of this particular problem that is known as the refugee movement. So it starts from 1951 and it is still going on. So this is how we should try to understand this entire what we call evolutionary phases of international migration. Now there is another important canvas to it. After this particular understanding of evolutionary phases of international development of migration or history of population movements, then we also come across evolutionary phase of international cooperation. If you take into account the period of that starts from 1685 and goes up to what we call 1918, we try to understand this particular stage as responsibility. In this particular phase, responsibility was realized by the community of nation states. In the post-Westphalian international legal order, international community has realized, but what was the dynamics of this realization of responsibility? The responsibility, my dear friends, has been realized as a domestic affair. That was the most important dimension of this particular period of time, that it starts from 1685 and goes up to 1918. So domestic nature of responsibility was realized. Then in the second important period, that it starts from 1685 and goes again, I'm talking of the same period, again 1918. Another important realization happens to be, and that is the legal basis was primarily domestic. It means the legal foundations of the domestic responsibility for protecting refugees was the realization in this particular period, that it starts from 1885 and goes up to 1918. Then another important period of time is also available, and that it starts from 1918 and goes up to 1951. In this particular period of time, another realization has also been there on the part of the community of nation states, and that is the responsibility was contended to be international. It means it has been contended by the community of nation states that the responsibility for the protection of refugees is of an international character. So there has been a contention. So see the evolution, how international community has been evolving to realize that it is, though first it has been realized that it's a humanitarian crisis, but at the same time they were struggling. They were in some kind of an intellectual limbo. They were not what you call very sure whether the responsibility of the refugees is of international character or of a domestic what you call nature. Though there was a consensus initially that it is a domestic what you call problem. It's a domestic responsibility. It is having a domestic legal basis, and therefore the protection of refugees domestically be what we call extended and realized. Then legal basis was also realized during this particular period. Again, the second important bone of contention has also been there, that we should contend that it is an international what we call responsibility with international implications and ramifications. Repercussions would also be international. Then the legal basis was also realized that it is having some international what we call legal basis. Then legal basis was primarily again contended, and a new expression was also coined by the scholarship, refugee scholarship, as well as with the political, while taking into consideration the political developments, the humanitarian developments during this particular period. It has been realized again, which is the same period that it starts from 1918 and goes up to 1951. It has been contended that the nature of the legal contention is of multilateral. So the idea of multilateralism was also realized. It is legal basis, it is having a multilateralism, it is also having some kind of a transnational, character during this particular period. So these were the new important, dimensions, and legal basis was ultimately agreed upon in 1951 convention. Though the convention was primarily addressing the European intracontinental migration, it was limited exclusively to this particular, geography or demography, which is today known as the European nation states. So its multilateralism has also been accepted up to 1951. Then the assistance to this kind of a displacement, that assistance was also what we call realized as a state responsibility. We would also be having certain important, the recommendations on state responsibility, particularly the International Law Commission. We would also be, having our, deliberations at a subsequent stage, but it should also be, understood at this stage, the assistance is a state responsibility during this particular period that starts from 1951 and is still continuing, which at the very outset of my, submissions today, I have, submitted that how in the New York Declaration, it has been politically realized by the community of nation states that the refugee problem has already transcended humanitarian character, and now it has also become a political issue of an international ramification. And therefore, Obama administration in 2016 came out with a proposal and proposed this particular, definition. This declaration in the form of soft law, which was ultimately concretized in the form of two global compacts. Then non-refoulement, another important facet. The non-refoulement of this international regime was also contended. And it was contended because the people have started talking of non-refoulement in 1932 onwards. And that is why it has also been located in the form of Article 33, subclause 1 of 1951 UN Convention relating to the status of refugees. It was further, incorporated in another important, convention under Article 3 of the, United Nations, Convention against, torture of 1984. Under Article 3, non-refoulement has again been, incorporated. Then non-refoulement has also been realized that it is also having an international character. No one should be forced to go back. There should not be any kind of a forced expulsion of an individual. So therefore, my dear friends, cumulatively it has been realized. And now we are having a different kind of a realization. And that realization has started with Harold Bont, late Mrs. Harold Bont. She has also enlisted this idea of non-refoulement. Professor Gaius Goodwin, Professor David Kennedy, then Brian Gorlick, then Gloucester, Erica Fowler. All these, guys have really what you call, came out a credible advocacy in favor of non-refoulement. And some of them, along with other important, scholars in the area of international refugee law, they also came out with a new kind of a, concept that the non-refoulement gradually gaining and locating its place in the entire schematization of the customary international law. It is attaining that kind of a stature in the entire scheme of customary international law. But if you see the entire drafting history of the United Nations Charter, you will realize, and it is also axiomatic from the preamble to the UN Charter, and particularly from those who drafted the Charter or UN Charter, and they were having in mind the painful memories of the generalized violence and mass sufferings, and called upon the signatories of the United Nations Charter to save succeeding generations from the scourge of war. So you can very well understand what is the meaning, what is the import, what is the background, what is the history of this kind of an expression incorporated in the preambular propositions to the United Nations Charter. The drafters of the United Nations Organization Charter also asked the United Nations to help achieve what? International cooperation in solving international problems of an economic, social, cultural, or humanitarian character. It is here, my dear friends, humanitarian character. This expression in the preamble to the United Nations Charter becomes very, very important. And therefore, when we talk of humanitarian problems, then the biggest problem, if you see the entire what you call inventory of the world problems, you will realize, and among these problems, the most conspicuous and visible problem happens to be the refugee crisis. Today, if you take into account the political map of the world, you will realize no continent, no region, no country, no nation state remains virgin. It has already been pulverized, plundered, infested with conflicts, violence of a massive scale. And there has been a forced refugee movement of the forced displaced population. Some countries happens to be the refugee producing countries, and some countries happens to be the refugee reception countries or refugee hosting countries. Because it is basically this particular expression in the preamble to the United Nations Charter that really promotes and encourages respect for human rights, preservation and promotion of the fundamental human freedoms, without any kind of a distinction, without any kind of a discrimination, without any kind of a dichotomies, without any kind of a predilections or preferences on the basis of race, religion, sex, language, or other important considerations. One of the first issues on the agenda of the United Nations was the fate of refugees, fate of destiny of the displaced persons, stateless persons, and returnees. Because if you take into account, these are the legal expressions: refugees, asylum seekers, migrants, stateless, returnees, or other categories, war refugees, and other sorts of what you call categorizations. These have been what you call designed to extend specific what you call fulfill the specific requirements of each category. But if you take into account their destiny or their what you call history of uprooting or displacement, then it is full of pain, and pain cannot be what you call divided into categorizations. Because pain and fear can only be accessed by those very people who have experienced it, who have endured it, who have realized it. And that is why we would be studying under week 3, when I am going to take up the definition, then we have to deal with the idea of fear. The contours of fear, the dissection, intellectual dissection of fear, that is the primary requirement, and how should we try to understand, how should we try to understand the various dynamics and dimensions of fear? Because there are, subjectivity, there is an element of, objectivity. And there is another important, considerations, like modern day considerations. Because the xenophobia, people getting, paranoid, then other important, national revanchism, jingoism, and narcissistic, ideologies. Everything we have to take into account, including fascism and Nazism, to what extent these have shaped the idea of what we call of, migration. Then the problem was, clearly understood, and there has been a commonality of understanding. The problem is both international and humanitarian. And now, after the passing of New York Declaration on Refugees and Migrants in 2016, it has also been, the category has got another important dimension. It has been, up to 2015, it was a cumulative international understanding of juridical and justicial scholarship that it is a humanitarian problem. It is an international problem. But after, 2016 or in the post what you call 2015, it has been realized not only it is humanitarian and what you call international, but at the same time, it is a political problem. So primarily, the declaration, New York Declaration, I am talking of the 2016, it was a watershed development. It is the turning point in the history of refugee protection. It is the most unprecedented development which I, in my personal capacity as a student of international refugee law, perceive that it is the most credible development. Because for the first time, the politicality, the culturality, and other important dimensions of this particular problem have been realized, recognized, and acknowledged by the world political leadership. That is why we have received these two important components, compacts, where we have been talking of the safe and orderly governance of international migration, where we have been talking of and celebrating the idea of the fourth, fifth, and sixth what we call durable solutions. The notions are emerging. Then we have been talking of the international solidarity in addressing the problem of refugees. Then we are also realizing the idea of responsibility sharing. Refugee does not anymore remain, my dear friends, burden, international burden. It is not a question of burden sharing. The burden sharing has already been replaced with the idea of responsibility sharing. That is the contribution of this particular declaration, and that is known as the New York Declaration on Refugees and Migrants of the 2016. So that is the beauty and that is the importance. And this is how we should try to understand, because it is also axiomatic. It is evident from the current developments. But if you take into account the legal and institutional framework for refugee protection, again I am taking you back to the history. In understanding legal institutional framework for refugee protection, then we should not forget other important organizations like International Refugee Organizations, IRO. At its second session in the later part of the 1946, General Assembly of the United Nations Organizations has established one of the most important credible organizations, which is known as the International Refugee Organization. And IRIO took over the task of the United Nations Relief and Rehabilitation Agency, that is popularly known as in abbreviation UNRWA. International Refugee Organization received a temporary mandate to register, protect, resettle and repatriate refugees. It means it has been empowered. IRO, that was established under the auspices of the United Nations Organization in 1946, was mandated to perform the task of registration of refugees, protection to refugees, resettlement of refugees, repatriation of refugees to their country of origin. The refugees came from almost or more than 30 countries during those days, my dear friends. Now refugees are emerging from each and every corner of the world. But during that particular period, in the middle of the 40s, people primarily coming from more than 30 nation states of Eastern Europe. From July 1947 to January 1952, that is a very, very important period again for the understanding of the refugee movement, a period of history of this particular period. Particularly, it becomes a very significant period for the functioning and working and operationalization of this international organization, that is RIO. Oh, I'm sorry, that is IRO. This organization helped to resettle over 1 million refugees, and that too in the third countries. It has almost repatriated more than 70,000 what we call refugees, and made arrangements almost for more than 4 lakhs who remain displaced in their home countries or in their country of origins. At the same time, we should not forget another important resolution after these developments under the auspices of the International Refugee Organization. But thereafter, there has been a resolution of the United Nations General Assembly Resolution 319 that has always been there on my fingertips. Under this particular resolution, United Nations General Assembly has decided to establish the Office of the United Nations High Commissioner for Refugees. This United Nations High Commissioner for Refugees office was set up as a subsidiary organ of the United Nations General Assembly on 1st of January in 1951. Though initially this particular office was contemplated for a temporary period, only for a period, or initially for a period of 1 year. The mandate of this particular office, the office of the UNHCR, United Nations High Commissioner for Refugees, has since been routinely extended for successive periods of 5 years. It now cares over millions of refugees worldwide. The Office of the United Nations High Commissioner for Refugees is presently located in Geneva, and it is represented in more than 100 nation states worldwide. As per the Article 1 of the Statutes of the United Nations High Commissioner for Refugees Office, the main task of the High Commissioner that has been contemplated under the statute is of providing international protection to refugees and to seek their durable solutions by assisting governments, by requesting governments, coordinating with national governments to facilitate the voluntary repatriation of refugees or their integration within new national communities. The High Commissioner, another important function, function per se, and that has been, branded as highly non-political person. This is the nature of his, function. Non-political, but at the same time, it is having some kind of a, social implications of the social nature as well. 1951, convention, I would be addressing as either refugee regime or the 1951 convention or refugee convention, or sometimes just for the sake of, clarification, I would also be resorting to the full-fledged expression of this particular, legal instrument adopted by the United Nations organizations in 1951. So 1951 Refugee Convention, which was drafted as a result of, recommendations by the newly established United Nations Commission on Human Rights. You already studied in your international human rights law classes how it has been, replaced with the United Nations, Human Rights Council. But during those days, it was United Nations Commission on Human Rights. So it was primarily the recommendation, and it was a landmark in setting standards for the treatment of refugees. 1951 Convention on Refugees, my dear friends, if you see its Article 1, we find a general definition of the term refugee, because it's a very comprehensive definition that has been provided. It is a definition which has been couched in general, what we call, terminologies. The term refugee applies to any person who, as a result of events occurring before 1st of January 1951, and because of the well-founded fear of being persecuted for certain important reasons, the reasons relating to race, religion, nationality, membership of a particular social group, political opinion, and that person finds himself or herself in a given situation outside the protection of his nationality or her nationality, and sometimes in the subsequent circumstances he is not in a position to return to its what we call or avail its national protection. Such kind of persons have been branded as refugees. But there is a lot of contention. The people are not satisfied with the current what we call form of definition that has been incorporated under Article 1 of the Refugee Convention of 1951. I would subsequently be dealing with what are the objections, oppositions, and other important what we call concerns expressed by the global South nation states, particularly Afro-Asian nation states, regarding the reception and how it has been what we call complemented by the regional definitions, and there are the national definitions of asylum as well as refugees. We would also be visiting some of the major national definitions. I would also be narrating in the week 3rd what kind of a definition I have contemplated in my PhD, which is exclusively on international refugee law. So how I have dealt with the definition aspect, and I have I have contemplated two important definitions, alternative definitions of refugees. I will also be sharing in the subsequent what we call week, and that is going to be the week 3rd or 4th. Then, my dear friends, primarily the 1951 Convention sets the minimum standards of treatment of refugees, and we should not forget those minimum standards. And minimum standards also includes, my dear friends, the basic rights to which they are entitled. And 1951 Convention also establishes the juridical status of refugees, This convention also contains provisions on their rights. I mean rights of refugees, particularly the right to gainful employment and welfare. On the issue of identity papers and travel documents, on the basis of or on the applicability of the fiscal charges, and their right to transfer their assets to another country where they have been admitted for the purposes of resettlement, reintegration, or relocation, or for the for understanding assimilation. 1951 convention prohibits the expulsion or forcible return of persons having refugee status. Because if somebody or some nation states have been indulging or have found to have been indulging or indulge in the forced deportation, then they are primarily in the violation of international law, particularly the customary international law. No country is going to brook, or the international law does not brook this kind of a violation. So therefore, it is the responsibility of the community of nation states to protect the idea of non-refoulement. And that is why I appreciate the actions of the government of Bangladesh. Despite their limited resources, despite their lack of infrastructural facilities, despite the fact the government of Bangladesh is struggling to cobble up some kind of a logistical support for the Rohingya refugees, even then, despite the fact that the government of Bangladesh is not a party to 1951 convention, even then it is protecting one of the most important fundamental principles of international refugee law, and that is the principle of non-refoulement, as adumbrated under Article 33, subclause 1. It is not violating that very principle. If there are violations, if there are some crimes which are prevailing, have been committed against Rohingya refugees within the camps, or if you take into account a week ago, even the camps of the Rohingya refugees were also set at ablaze. There has been a fire. The fire, particularly in the refugee camps in Europe and particularly in Germany on the border areas in Hungary, there have been same kind of a fire got replicated in Rohingya refugee camps. So that has also posed a new kind of a challenge: how to ensure the safety and security of refugees in the camps, and that too particularly during the global pandemic. Right to health, right to safety and security. These rights in the refugee camps have got an added what you call importance. Now the government of Bangladesh has already started the resettlement program of Rohingya refugees by sending and transferring and transporting some of the groups of Rohingya refugees to a barren island in the Indian Ocean. I am not discussing the efficacy, relevance, as well as the hospitality of this particular island, but at least the government of Bangladesh should rightly be credited with this kind of measures. They are very seriously contemplating how to have the resettlement, how to have the repatriation, because repatriation has not been successful. It has never been what you call successful, particularly in our part of the world, that is Southeast Asia or the South Asia. Same kind of a situation is being faced by the Afghan refugees in Pakistan, despite the fact there is a pursuance of 1993 bilateral agreement between government of Afghanistan and the government of Pakistan for the repatriation of Afghan refugees back to their own country of origin, and that is Afghanistan. So how we have been, dealing with these kinds of what you call, problems. This is of vital importance, because expulsion or forcible return of refugees have never been, recognized. Whether it is under international refugee law, under international human rights law, under international humanitarian law, under customary international law, nor under international criminal law. No law is, recognizing. Rather, we find an advocacy for the integration and for the durable solutions of the refugees. Because if you take into account Article 33, it mandates no contracting state shall expel. That is the language. This is how it starts. No contracting state shall expel or return in a forceful manner. I'm not able to reproduce the exact language, but this is the mandate of 51 Convention. If you read Article 33 under it, because not only Article 33 subclause 1, even the Article 33 subclause 1 also enumerates all the grounds of expulsion. But if you take into account the subclause 2 of Article 33, then some kind of a leverage, some kind of a relaxation has been provided to the national governments, because the national governments have always been in the habit of invoking second clause of Article 33. And that is what we call in the name of the national security, in the name of terrorism, in the name of prosecution, in the name of some other ulterior motives. Because those grounds sometimes have been found highly unfounded one. There is no credibility, there is no credible evidences. Only the sham images have been created. Some kind of an indoctrination drive is going on in many of the geopolitical entities against refugees in the name of the far right nationalism, in the name of racism. But no government is ready to accept that this kind of racism is prevailing in their backyard. No, the governments are wary of accepting these kinds of prevalence. So that has ultimately emasculated the idea of what we call the refugee protection. That has really undermined and decimated the national commitments to the international human rights endorsements. Because the international idea of international solidarity and international protection and the concept of state responsibility got weakened because of the non-realization and non-acceptance. And this is being done not by the governments, but there are state-sponsored actors, non-state actors, state-patronized non-state actors. They have been creating problems for the national governments, and that is why we should not forget Article 34 as well. Because Article 34, my dear friends, pertains to the naturalization and assimilation of refugees. There are other provisions as well. In addition to Article 33 and Article 34, other provisions deal with many other issues relating to the refugees, particularly the such rights, access to court or the judicial accessibility, right to education, right to social security, right to social support, right to housing, freedom of movement, right to religion, right to gainful employment, number of rights. Whatever the rights have been recognized, my dear friends, in the national constitutions of major democracies or other important presidential form of governances, we also find the similar, including the South Asian constitutions. In majority of the South Asian nation states, we do not have any kind of a refugee specific legislation except Afghanistan. though it does not have any kind of a legislation, but it has become a party to 1951 convention relating to the status of refugees. As of now, there are as many as 148 nation states who have become the party to 1951 convention, as it has been reported up to 2015, by the end of the 2015. In the post 2015, no other nation state has come up for exceeding or acknowledging or signing 1951 convention. So, but the customary international law and the national constitutions have always been present there within the national jurisdictions for the protection of aliens, foreigners, migrants, refugees, asylum seekers, or the persons who are demanding refugee status, or the people who are fleeing persecution and knocking the national boundaries of the nation states. That is the situation. Then comes, after 1951 convention, we have also been witnessing the arrival and the adoption of 1967 protocol, additional protocol, additional to the 1951 convention. Because up to 1966, United Nations sponsored and concluded 1951 convention relating to the status of refugees was primarily applicable to European nation states alone. But after its adoption, in the subsequent years, it has been realized by the community of nation states that the refugee problem is not confined to European nation states alone. Rather, it has attained some other geopolitical dimensions in other nation states. And it has also been further realized that the people happens to be on the move in other parts of the world. And therefore, with a similar mandate which was contemplated for the European nation states under the auspices of the United Nations Organization, it has been realized by the collective wisdom of the international community. Let us have the application of this particular document, which is exclusively applicable to the European nation states. Let us make it universal, international one, the global one, and therefore they adopted an additional protocol that ultimately removed all kinds of geopolitical demarcations and limitations. And it has been, additional protocol has been adopted in 1967. So in the post 1967 period, we got an international law on refugees in the form of 1951 convention, refugee convention relating to the status of refugees. There has not been any kind of a changes. No change has been carried out in the schematization of 1951 convention, but it is having normative, substantive, as well as the processual value. And some of the provisions of 1951 convention have attained the status of, or have become akin to the idea of customary international law. Erika Feller, a very, very important scholar, a lady scholar of international refugee laws, she came out with a very novel idea. And the title of her contribution goes like this: Refugee Convention still matters, with an interrogatory mark. And ultimately, if you go through that very article, I will definitely share that particular article, a very brief one. In this particular article, in the ultimate analysis of her, she has established, she concluded the efficacy, relevance, and significance of 1951 convention, and it is still relevant. And the adoption of the two important, compacts, my dear friends. So this is my humble submission to all of you, that in the area of international refugee law, we have to deal with each and every other law with a sense of complementarity, compatibility, and supplementarity. You should not foresee, you should not what you call, perceive or have some kind of a precise understanding that such and such law is different from and that contravenes such and such provisions of international refugee law. No, we have to create an element of complementarity. We have to create an idea of conformity, because all the law in the name of international human rights law framework, in the name of international humanitarian law, in the name of international criminal law, international what we call constitutional law or customary international law, they have been designed in such a fashion that they are primarily supplementing, complementing, and conforming to international, or conforming with international refugee law. So along with these two important major subject matters of international refugee law, that is 1951 Convention and the additional protocol of 1967, they have been supplemented and complemented by rest of the what we call instruments of international law. So that understanding, if something is not palliable, if something is not at all resolvable with the application of the provisions adumbrated in 1951 Refugee Convention, then definitely we should what we call, suppose there happens to be a refugee problem and we are not able to solve or address that particular refugee problem by applying 1951 Refugee Convention, then in such a situation, my dear friends, it becomes our responsibility to understand the application, to invoke the application of international human rights law. So element of complementarity, we have to supplement and complement. So this should never be forgotten, because time and again I would be emphasizing during my interactions with all of you all these aspects, and it is going to be a pervading line of argument. It is going to be the most conspicuous submission of mine. Now, if we try to understand the importance of additional protocol of 1967, and before I proceed further from here, let me check your chat box as well. Something is there. Okay. No questions are there, only the courtesies. 1967 additional protocol has provided some kind of a processual smoothness for the implementation of 1951 Convention. Because the 1951 Refugee Convention could benefit only persons who had become refugees as a result of 1951 or as a result of the events which occurred before 1951. But the years following 1951 period showed that the refugee movements, as I have already submitted, were also happening in other parts of the world, particularly the Afro-Asian what we call regions were also addressed. And the biggest what we call contribution of the 1967 protocol was that under this particular protocol, the application of the 1951 Convention also started to address the new flow of refugees. And these new refugees were the persons who, while meeting the convention definition, and they have, or had become, refugees due to the, events in the post-1951, period. And the convention, further specifies that a person or group of, persons shall not be deprived of their nationality on racial, ethnic, or religious or political grounds. That is the major contribution of 1967 additional protocol. I would also share one of my important, research paper on this particular, aspect. particularly in the area of international statelessness law, vis-a-vis, right to nationality, that has been, published in an international journal, that is the International Journal or Groningen Journal of International Law, published from the Netherlands. And if I am correct in my recalling, I think this research paper got published in the year in 2017. I will share that, research paper as well, where I have been, I have talked of right to nationality and what are the, other important, dimensions of right to nationality, particularly in the cases, in the situations of, or in a state of statelessness. 1967 additional protocol to 1951 Refugee Convention is a very landmark, what we call, contribution. But at the same time, we should not forget 1967 United Nations Declaration on Territorial Asylum. If you take into account this particular territorial declaration on asylum, this declaration also lays down a series of fundamental principles in regard to territorial asylum. Territorial Asylum Declaration of 1967 is a peaceful and humanitarian act because it has been branded asylum is a peaceful institution. Particularly the territorial asylum, again, it has been branded under this particular, definition, or in this particular, declaration, soft law of 1967. Then the territorial asylum is a peaceful and humanitarian act, and it cannot be regarded as an unfriendly act by any other, state. If you take into account Article 14 of the Universal Declaration of Human Rights that guarantees right to asylum under international law on human rights, or right to seek asylum in another country, then granting of asylum to individual acts should not be perceived by the country of origin or country of nationality of that particular, persons, or the government of his, country of origin should not perceive this granting of asylum to Mr. X as an unfriendly act. This has also been what we call, stamped under this particular, Declaration on Territorial Asylum of 1967. See the, canvas. When we are, talking of specialized groups of people, and refugees are one of them, or as a group is one of them. This is very, very important when we are talking of highly specialized, groups under international law. So, Territorial Asylum Declaration has perceived the idea of territorial asylum as the highly placid, calm, peaceful, what we call, notion of, act. Because right to territorial asylum, and particularly so far this particular declaration on territorial asylum of 1967 is concerned, then it holds the basic humanitarian principle of non-refoulement. And it recalls Article 13 and 14 at the same time. Article 13 and 14 of the Universal Declaration of Human Rights of 1948. Because Article 13 takes into account the right to leave any country, right to return one's, country. That is the beauty of, Article 13 of the Universal Declaration of Human Rights. And I have already explained what exactly is the import of Article 14 of the Universal Declaration of Human Rights, because that incorporates, or this particular article incorporated the entire international law on asylum under one article, and that is why the Universal Declaration of Human Rights is a normative document. It's a substantive document. And today we find voluminous books, research papers, blogs, articles, opinions of the jurists, judges, thinkers, and the scholars in the field of international refugee law. But it has been realized, my dear friends, in 1948, the entire institution of asylum. And today it remains shrouded in controversies. It is full of what we call of contentions, contests, and it has become highly controversial and abused institution under international law on human rights. Because if you take into account some important regional arrangements, like suppose Africa, we have been witnessing the growing numbers of refugees, and these refugees are also fleeing wars, internal conflicts. And since 50s, we have been witnessing and ultimately leading to the adoption what is generally considered the most comprehensive and significant regional refugee treaty, where under the entire what we call idea of refugee protection has been contemplated. I am talking of, my dear friends, the Organization of African Unity, OAU, what we call organization. Then it has also adopted in the year 1969 a convention which is exclusively devoted for the protection of refugees, and that is OAU Convention governing the specific aspects of refugees in Africa. And the primary importance, my dear friends, of this particular African Convention is its expanded definition of the term refugee. And what exactly are the contours, what are those very terms upon which a new understanding of the refugee definition has been given. I would also be deliberating those fundamental aspects tomorrow at the same time. So thank you very much for the day. And it has been a very nice, as many as around 9 students as of now have joined. So I wanted the 50% of the students of the International Human Rights Law class. That was a compulsory paper. But from this year, that is 2021, International Human Rights Law paper is also going to be an optional one. So thank you very much. Now, let me invite your questions. So tomorrow I am scheduled to take up the regional understanding of the definition, though we would also be a very, very limited, treatment I would be sharing with all of you, because we also, we have designed, so far our course structure is concerned, a full-fledged week, because the definition part is the most contended, controversial and convoluted, aspect of entire, understanding, entire discourse on international refugee law. So anyway, please, yeah, please. Ms. Prakriti,
yes, sir. I have a question regarding to the fifth phase that you talk about, that is related to effective internationalization. So here the term effective has been used to denote the scenario of refugee right now. So my question is, can we really consider the present scenario as an effective internationalization phase? Because as you said, even in the member of the Refugee Convention, if you see the member of the Refugee Convention, it's hardly 147. So though I understand that some of the principle of refugee law has been established as a customary international law, but if we see the refugee law as a whole, can we really consider this phase as a effective internationalization stage?
Ma'am, I understand your concern. You are not comfortable, intellectually speaking. You are juridical, justicial, and intellectual understanding is agitating you, because there is no stability. But this is my contention. This particular phase starts from 1939 and up to 1951. It has been a realization. But if you see the post 1951 scenario, then definitely we are of the view that considerable, significant, and lot of amount of energy has been invested by the entire international, regional, and continental scholarship for the realization, for the recognition that the refugee problem should be recognized at international level. But passing of 1967 additional protocol to 1951 convention ultimately brought the day when international community has realized in the effective terms that it has got international ramification as a problem. As a humanitarian crisis, it is having international ramifications. As a social issue, it has also got some international as well as anthropological dimensions. So I do believe that in the post 1951 scenario, refugee problem has really got its international visage, or it has been internationalized. And that is why, if you take into account this entire journey that it starts from 67 and goes up to 2016 in New York, then it is the full-fledged internationalization of this particular problem, and that too on the basis of the political realization or the political footing. So I do not have any kind of a compunction in realizing and admitting, yes, of course, in this particular period, there has been a drive. And as a student of, international refugee law, as a, this is my humble submission to all of you. Yes, of course, we are correct when we have, we are putting forward and realizing the international dimensions and international character of this particular, problem. And so far your contention is concerned, because the word internationalization has been prefixed with an adjective which is known as effective, which you have very conspicuously pointed out. Yes, there has been realization in the form of pragmatism, in the form of results. There has been a result oriented internationalization, because UNHCR has become a permanent feature. So initially, after the collapse of one of the most important international organization, that is the International Refugee Organization, that was established in 1946 under the auspices of the United Nations General Assembly, that was replaced by the Office of the Statute under the statute of the UNHCR in 1950, and further on the recommendations of the United Nations Commission on Human Rights, then it was again realized, let us have a permanent what we call institution as a subsidiary organizations of the United Nations organization. So that ultimately these developments, if you are going to take these developments on a collective footing, you will realize that there has been a sincerity on the part of the international community without any kind of political support. As a multilateral organization, considerable developments have been there, considerable programs for the resettlement, reintegration, assimilation with the local what we call communities of the international what we call displaced populations in the reception countries has also been there. And that is why some of the nation states have become, particularly the United Nations, United States of America has become a land of migrants. Multiculturalism and diversity is being celebrated in many parts of the world because of refugees. So migration has always been there, and this particular period of history that it starts from 1951, and particularly if more what we call strictly speaking, than the period that it starts from 1967 and goes up to 2016. This is a period which I call, in the true sense of the term, as the effective internationalization of the refugee issues and refugee problems. So this is my submission. Any other observation, comments, inputs? Yeah, thank you very much. See you tomorrow very positively. I would be starting my submissions tomorrow from this particular point where, and I will begin my submissions from Ms. Prakriti Manda's observations. Yeah, thank you very much.
Thank you, sir.
Thank you, sir.